So good morning, everyone, and welcome to our annual employment law update live from London. For those of you who don't know me, my name is Miriam Bruce. I'm one of the partners in the employment team here at Mayer Brown. I'm chairing today's update session, and our speakers today will be Chris Fisher, head of the employment team, Senior Associate Francesca Ingham, and Counsel and Head of our European Mobility Practice, James Perrett. Now, when we picked the date for this seminar, we had no idea that we'd be just a week away from the general election. But that's where we find ourselves. And our session today, as you'll see from the agenda, which is just coming up now, will have a strong election theme. Both Chris and James will be covering what a new government will mean from an employment law and a mobility perspective. But for those of you who are already fed up with the election, we'll also cover some non-election topics, including an update from Chris on how the FCA and PRA continue to influence employment law trends and strategies. We're going to kick off in a moment with Fran talking us through a case law and legislation update covering sexual harassment, redundancy and flexible working. And I'll hand over to her in a minute. But just to let you know, there's the ability to ask questions. There's a chat or Q&A boxes. Put your questions in there. We'll run through all of the questions at the end, or as many as we can get through in the last 5 to 10 minutes. So please do submit them as they come to mind, and I will try and get through as many as possible at the end of the session. If we don't get through all the questions, though, we'll follow up with our thoughts in writing, and we'll also circulate the recording of today's session and the slides too. So without further ado, I'm going to hand over Fran to kick us off on the new duty to prevent sexual harassment.
Hi. So as Miriam said, there's a new duty on employers to prevent sexual harassment in the workplace, which is going to come into force in October this year. By way of reminder, currently the Equality Act prohibits sexual harassment and also any less favourable treatment because an employee has rejected or submitted to conduct of a sexual nature. Employers can be vicariously liable, but there is a defence if employers can show that they took all reasonable steps to prevent the harassing employee from acting unlawfully. However, it was felt that this existing defence was inadequate to protect workers, and it didn't incentivise employers enough to take action. So as a result, this new duty is being introduced, which will actively require employers to take reasonable steps to prevent sexual harassment during the course of employment. Question, therefore, for many employers is going to be, what does this new duty mean in practice? Well, at this stage, it remains unclear what will constitute reasonable steps, and the Equality and Human Rights Commission has stated that it plans to update its technical guidance. But based on previous case law, it's anticipated that it will include taking measures such as having an anti-harassment policy and reporting procedure in place, ensuring the policy is communicated regularly within the workplace and that it is monitored and reviewed regularly, and that appropriate training is implemented and that also refresher training takes place. It's important to be aware, however, that this duty is not going to create a new standalone claim in the employment tribunal, but claims for the breach of the new duty will be considered if an employment tribunal has upheld an employee's claim for sexual harassment. This means that if an employer is found to have breached the duty, the employment tribunal then has the ability to increase any compensation award by up to 25%. So it could have a significant financial impact on employment tribunal awards in due course. The next topic I'm going to cover is redundancy, and focusing initially on the new legislation that has come into force, the Protection from Redundancy, Pregnancy and Family Leave Act 2023, which came into force from the 6th of April 2024. And these regulations have introduced a number of key changes in relation to redundancies. The key change is that it's extended the priority status for redeployment opportunities in a redundancy situation to pregnant employees and also those who have recently returned from maternity leave, adoption leave, and shared parental leave. As you'll be aware, under the previous legislation, the protection only applied to employees whilst on the leave itself. The period of the protection will depend on the type of leave that's ultimately being taken. So, for example, for those taking maternity leave, it will start when the employer is notified about the pregnancy and ends 18 months from the child's date of birth. This could, in effect, give employees nearly 2 years of priority status if they notify their employer at 12 weeks of the pregnancy. But it is important to bear in mind that this protection only offers priority for redeployment opportunities. It's not a complete ban on making employees redundant during any of these periods of protection. It will also only apply to pregnancies notified after the 6th of April and adoption and maternity leave ending after that date as well. So really the key impact of this new legislation is that it's going to be important to bear in mind these changes when conducting any redundancy process going forward. It's going to be necessary to ensure that an analysis is undertaken at the outset to determine which employees are going to be eligible for this priority status for redeployment, which is now going to cover a wider group of individuals going forward. Next, I'm going to turn to some recent cases in relation to redundancies, the first of which is Haycox. And this was one where, as part of a redundancy exercise, the defendant, who was a UK subsidiary of a US organisation, used standard selection criteria from the US parent organisation to rank members of the claimant's team. The claimant then received the least favourable score and was selected for being placed at risk of redundancy. He was invited to an initial meeting where he was informed of the need for redundancy and the purpose of the consultation. He was then invited to one meeting only throughout the consultation period, and at the end of a 14-day period, he was given a letter confirming his redundancy. On appeal, the Employment Tribunal found that there were deficiencies in the redundancy exercise, as the affected employees had not had a chance to impact the redundancy decision, and there was no opportunity for an alternative approach to be proposed. So I think this case really clarifies that employers need to ensure that the consultation process is and is seen to be meaningful. It's necessary to consult at an early stage about whether making redundancies or not, particularly before decisions are made, to enable employees to have a real opportunity to influence that final decision. It also demonstrates that employers need to have considered alternatives as well. There has also been a recent case, Valamula and the Al-Kahir Foundation, which builds on this case a bit recently. This was a case where the company considered the individual to be in a pool of one, despite other employees carrying out a similar role in other geographic locations in the UK. On appeal in the Employment Tribunal, it was held that the consultation on redundancy had to take place at a time when it could make a difference, as in the Haycox case. It also held in this instance that the respondent had not consulted about the pool for selection. It therefore builds on that decision in Haycox about consultation taking place at these formative stages, and also that it must include consultation on whether pools were considered, how it reached its determination, and any criteria used. It's not sufficient to simply notify the individual that they're in a pool of one. I think this case also highlights how the Employment Tribunal does not look favourably on pools of one, and that it expects employers to consider at least having a pool, even if the work is not the same or similar. Moving now on to the final topic that I will be covering, which is the flexible working requests. So from the 6th of April 2024, there's been a number of family-friendly laws that came into effect, including in relation to flexible working arrangements. This new legislation is called the Flexible Working Amendment Regulations 2023, and it's made a number of key changes in relation to that statutory procedure for flexible working requests. So by way of reminder for everyone, flexible working can refer to working patterns, an individual's hours, or it could cover where they're working from. e.g. whether they're working from home. The key change under this legislation is that flexible working requests have now become a day one right for employees. So they no longer need to have that qualifying period of service, which was previously 26 weeks. They're now also enabled to make up to 2 requests in any 12-month period instead of 1. And it's also shortened the time frame for employers to reach a decision on a request. So they've now only got 2 months rather than 3 months to respond. There's also been a change in the information that employees are required to provide as part of their request. So previously they had to state the impact that their request would have on the business and how the employer could mitigate it, but it's no longer necessary to provide this information. And so there is, however, one change in employers' favour, which is that an employer can treat the request as having been withdrawn if without good reason the employee fails to attend a meeting to discuss their request, as well as a further rearranged meeting. Again, it's important to bear in mind that while there are changes to the process, there is still no guarantee that flexible working requests will be granted by an employer. So really, I think the key impact of all of this new legislation is that it's important to ensure that companies' internal policies are up to date and able to reflect these changes in employee rights in the procedure. And then the final bit that I will talk about is just one recent case in the area of flexible working requests, which is Wilson and the Financial Conduct Authority. This is a case where an employer refused a senior employee's flexible working request to allow her to work from home full-time due to concerns about the impact on the business, despite her successfully working from home since the start of the pandemic. Ultimately, the tribunal ordered 1 week's pay as compensation for the appeal not being held in a timely manner, but her claim that the decision to reject her request was based on incorrect facts was not upheld. The tribunal held that the line manager had carefully analysed the factors for refusing her request. And in this instance, the FCA had concerns about her ability to carry out face-to-face training, to attend away days, to coach new joiners, and as well as concerns around the importance of junior colleagues being able to meet senior managers face to face. So I think this is an interesting case to be aware of as businesses start to increase the number of days that employees are required to attend the office, which may result in an increase in due course in flexible working requests. I'm now going to hand over to Chris, who's going to talk about the election proposals.
Thanks, Fran. Good morning, everyone. So I'm going to start off, as Fran said, with the election. I believe we have an election coming up shortly in the UK. So obviously we wanted to have a look at what's going to be happening. We have been tracking the main parties, but in the time available this morning, I'm going to focus on the Labour Party proposals, not just because of what the polls are saying, but also because they have had by far and away the most to say on employment and employment law changes. But there is a slide at the end on what the other parties are saying. So Labour have said that in their manifesto document, which they published a standalone employment manifesto document, which some of you may have had a look at. It's 20-odd pages just on employment law changes, and they've said that if they win, then they will legislate in the first 100 days of taking government. Now, we think they've also said that they will consult, which is encouraging given some of the changes they're proposing. So I think the thinking is that they may bring out a draft bill in the first 100 days, and there may be some quick changes they can make, but most of the significant changes they're proposing will require some form of consultation process. So I'm going to look at a selection. I'm not going to look at all of them because there are so many, but I've tried to pick out the ones that we think are most relevant to you who are likely to be on this call this morning. But it's fair to say that they are very, very significant if they bring most or all of these changes in. So the first two I'm going to look at are changes to unfair dismissal and worker status. And these are the ones that really caught the headline, so you'll be aware of these probably. But possibly the single most significant change is the proposed change to unfair dismissal law. And they are removing the current qualifying period. Now, you'll see there my deliberate mistake on this slide. It is not a 1-year qualifying period for unfair dismissal. It's a 2-year qualifying period. The last time it was 1 year, it was when we had a Labour government, and that ended in 2012 when the Conservatives came back in and put it back to 2 years. But I mean, since unfair dismissal law came in 1971, there has always been a qualifying period of some sort. It dropped to as low as 6 months, for those of you who can remember that. But it's either been at 1 year or 2 years, depending on which government was in power. So this really is a massive change in approach, because it's essentially until now been a 1 year or 2 year probationary period for employers where they could terminate employment fairly easily during that period of time and not have to worry about unfair dismissal law. Yes, there are day one claims such as whistleblowing and discrimination, but for unfair dismissal purposes, it was fairly straightforward. So I think that this is very, very significant. They have that. The paper says that they will have a probation exception. And so I think probationary periods are going to become absolutely key in employment contracts. So if you don't have one, make sure you do put one in your contracts going forward, because the thinking is this won't be a retrospective change. This will apply to future hires when the new law comes in. And so a probationary period will be key. They've also said it's probation coupled with a fair and transparent process. Now, we don't know what that means, how much of a process an employer will have to go through, but I think it's going to be more than the current very light touch end of probation. You're not quite good enough, off you go with your week's notice. It's going to be more than that, possibly certainly a meeting and a discussion and maybe a right of appeal. But I think the key thing for now is to make sure you have a probation period in your contract. The other thing to mention on unfair dismissal, which was in the green paper that Labour produced a couple of years ago, they also were proposing to remove the compensation cap, the 1 year's cap on pay, which has been in there for, there's always been a cap on unfair dismissal compensation for a long time. That then I think really would be a game changer if they make both of those changes. In the latest manifesto, the removal of the compensation cap is not there. So the general thinking is that may have been dropped, but it was there before. So we'll wait to see whether that raises its head again. But that's unfair dismissal. The other big change that's hit the headlines is worker status. Currently, we have the 3-tier status of worker, self-employed worker and employee. In the UK, we have that slightly odd middle ground of someone who's a worker who's not self-employed, but they're not quite an employee. Labour have said that's far too confusing. We're going to remove the middle category. Everyone will either be self-employed or employed, and they'll have the rights that go with that. So really what it means is giving workers full employment rights. So giving them unfair dismissal, sick pay, maternity leave, paternity leave, all of those rights that at the moment are exclusive to employees. So significant increase in cost for those businesses who have workers in them, whether that's consultants, agency workers. The gig platform businesses such as the Ubers and the Amazons are going to be looking at this very carefully. The elephant in the room, really, what's not been said is Labour also proposing to tax the new employees as employees, because if they are, then that may be a disincentive on some workers who at the moment are quite happy having the rights of a worker, so minimum wage, holiday pay, pension, but being taxed as self-employed. And certainly that's attractive to businesses doing it that way, significantly more expensive to engage an employee than a self-employed worker, even if you do have to provide holiday pay, minimum wage and pension. So that has been left unsaid. Many people are saying this is possibly partly how Labour are looking to pay for some of their changes, the significant national insurance gain they would bring from taxing the new workers as employees. But again, it's been silent in the manifesto. So we'll wait to see on that one. The next couple of changes on the next slide I'm going to mention are, first of all, fire and rehire. So this again has been in the headlines. This is the process under which an employer can terminate a contract and replace it with a new one. And it's ever since the P&O situation a couple of years ago, where P&O terminated all of their workforce and replaced them with cheaper labour from Eastern European countries largely. fire and rehire has come to the fore. It's always been a practice that has been going on for a long time. People became aware of it when the P&O situation happened, although P&O was actually a fire and replace. It wasn't a fire and rehire, because the P&O workers were not rehired. They were replaced with different workers. Labour have said, we will go further than the current Conservative proposal, which is the code of practice that's about to come in, that really just puts more process around fire and rehire. It doesn't outlaw it. Labour have said, initially they said they would ban it. They've now come back a bit from that and said we won't quite ban it, but it will only be allowed if there's genuinely no alternative. And we don't really know what that means, whether that's a different way of saying there needs to be an exhaustive process gone through, or does it really mean the business is going to have to show it is going to fail unless it makes the changes it wants to. But I think one thing is clear, is that there will be an increased importance of flexibility clauses in contracts. So where you have benefits, incentives, pension schemes, you're going to want the unilateral right to change those things without having to go through a fire and rehire process. And so I think there'll be increased focus on the flexibility that goes around some of the clauses in our contracts. That's fire and rehire. The other one, collective dismissals, it's worth mentioning, not had a lot of publicity, this one, but at the moment, as you know, in a collective redundancy or other dismissal exercise where you have 20 or more people in a 90-day window, you have to carry out collective consultation with unions, employee reps, etc. At the moment, that 20 number is split up. So if you're a multi-site employer, you can take the numbers separately at different sites. You don't aggregate them. And that there was the Woolworths case a few years ago, which held that was the case. And so Woolworths was able to avoid a lot of collective consultation, or reduce the amount of collective consultation it had to do, by showing it had lots of pockets of small redundancy exercises. Labour proposed to scrap that. They won't have the concept of establishments anymore. They will aggregate the number across an entire employer's workforce when it's proposing redundancies. So far more probably redundancy exercises caught by the collective dismissal laws. So that's one they're going to bring in. And lastly, on this slide, tribunal time limits, currently generally 3 months, apart from redundancy and equal pay, which are 6. Labour have said they're going to increase them all to 6 months to bring them all in line with redundancy and equal pay. That they say will reduce the number of claims in the tribunal, because it will allow more time for internal processes. I'm not so sure. I think it will increase the number of tribunal claims, because people will just have longer to think about them and bring them in. And when you look at the other changes that are coming in, unfair dismissal, worker status, there are going to be far more claims going through our tribunal system, which, as many of you who have experienced the joys of the tribunal process, is not the fastest process in the world. They're massively under-resourced. And I think increasing the limitation period is probably not going to help that. So also obviously increases the period of uncertainty for you as an employer in knowing, is this employee going to bring a claim or not? It's already been extended quite a lot by the mandatory ACAS conciliation process to closer to 5 or 6 months. When you add that on to the 3-month limit, we're now talking about another 3 months on top of that. So that's tribunal time limits. And then the last two I'm going to mention on the Labour proposals are discrimination and pay gap reporting. So discrimination, Fran has mentioned the additional protection for returning pregnant employees after maternity leave. Labour will go further than extending the right of first refusal to an alternative job for a returning maternity leaver. They will ban dismissal for 6 months following maternity leave. So they will go much, much further. Now we'll wait to see how that is drafted, whether there'll be any exceptions to that, whether it will just be related to redundancy or other grounds as well. But they are going to put in place a much more secure ban on dismissal protection for that 6-month period. Flexible working, again, just picking up on one that Fran mentioned, again, Labour have said they'll go further than the current Conservative government have gone in terms of the right to request flexible working. Labour will make this a right to flexible working. So not a right to request, which can, let's be honest, can be fairly easily kicked back by an employer under the current regime. They will make that a right to a flexible contract unless it is not reasonably feasible. So I think this is going to have a big impact with employers who are looking to get people back into the office and can at the moment push back, as they did in the FCA case that Fran mentioned, by saying, well, we want you back for more face-to-face contact. We think it's a good thing. We're better together. We're right to connect with you. That doesn't mean it's not reasonably feasible for that person still to do that job in their home. So I think that if that comes in, that will possibly shift the landscape on return to the office a little bit. And lastly, on discrimination, again, picking up on another one that Fran mentioned, the new duty, positive duty to take steps to prevent sexual harassment. Labour will, they say, beef that up to make it a duty to take all reasonable steps, not just some reasonable steps. So that will, I think, significantly enhance that obligation on employers. And lastly, pay gap reporting. At the moment, it's limited to large employers, 250 or more employees, and it's limited to gender. It's the gender pay gap reporting. Conservative government decided not to extend it to include other protected grounds. Labour have said they will extend it to include ethnicity and disability. So and as we know, those are more difficult to collect data on. Employees may be less willing to give that data, whereas employers at the moment often hold gender data already through other means. So that's going to be a more difficult exercise for employers who don't already collect that data. Also, they'll go further and require not just the data to be reported on, but also there'll be a duty, which there isn't at the moment, to publish an action plan on what is the employer looking to do to reduce that gap. They'll also include in the numbers outsourced workers, which is an interesting concept. I think that's going to make life significantly more difficult for employers if they have to look at all of their outsourced contracts and workers engaged under those. And lastly, they will introduce a new duty, not to publish data, but to publish a menopause action plan. So a lot more reporting activity for larger employers. This is still restricted to the larger employers, 250 plus, but a much more significant burden for them. So that's the Labour proposals. I'm not going to go through, given the time, I'm not going to go through the other parties. As I say, not because of the current polling, but just because the other parties haven't had as much to say the least on anything. Liberal Democrats have said a bit more on the family-friendly situation, some quite interesting proposals from them. And if Reform are elected, we will probably have no more employment law because they're going to remove anything based on EU regulations, which is a lot of our law. So that will be interesting. So those are the other parties' proposals. I'm going to go on now, because of the time, to my other topic, which is a regulatory update for those of you on the line who are financial services employers. If you're regulated by the FCA and or the PRA, this is going to be of interest to you. And so what happened was there was, as you know, there's been a consultation paper that came out towards the end of last year, twin consultation papers by the FCA and the PRA, looking at two core things: diversity and inclusion and non-financial misconduct. And on top of that, in February this year, some of you will know, in the insurance and wholesale bank markets, they issued a survey to firms on non-financial misconduct, getting a view on how many incidents of non-financial misconduct those firms have experienced in the last 3 years, what types were they, how were they reported, did you have an NDA at the end of that, did it result in a tribunal claim, trying to pick up a bigger picture of what's been going on. They've had about 1,000 responses to that survey, and they'll be coming out with the results of that survey later this year, they've said. And in fact, what we expect on these papers generally is policy statements from both the FCA and the PRA at some point later this year. And then those new rules will come into force 12 months later. So there'll be a 12-month lead in time. So what are they? If we look, first of all, at diversity inclusion, if you just go to the next slide, thanks, George. The big thing to note on diversity inclusion, it is essentially a data reporting obligation on regulated firms. There is a big difference if you're a small firm or a large firm. Small firm is 250 or less, large firm is 251 or more employees. If you are a small firm and you're only FCA regulated, there really is no D&I reporting obligation other than to report the number of employees that you have. It is voluntary whether you want to do the reporting that a larger firm would have to do. The exception to that is if you are PRA regulated, then there is an obligation, whatever size you are, to publish a D&I strategy and to monitor internally your D&I to a certain extent, not necessarily to the same extent as is required for large firms, but generally speaking, a much lighter touch for small firms than large. And that has received quite a bit of criticism in the recent Sex and the City inquiry carried out by the Treasury Select Committee. They criticised the FCA on making this distinction because they said it's really the small firms where a lot of these problems and a lot of lack of diversity exist, and they think this is really what they have called a tick box exercise for employers, and the committee said it's a waste of time and it should be dropped. The FCA have come back and said, no, we're not dropping it, we're carrying on, we think it's important, and for proportionality reasons we want to make this distinction between large and small firms. So for large firms, the obligation is quite significant. It's a duty to report and publish your diversity data, and I'll come in a minute to show you what that is. But it's a wide range of demographic diversity data that will have to be reported on and then published. Also, an obligation to publish a D&I strategy, and interestingly, D&I targets. So that's going quite a long way, and that will be of concern to, I think, Anglo US firms, where the concept of a target gets people very nervous, given their affirmative action laws over there. But that will be a requirement for firms in the UK. They expect at least 2 targets, they have said, and they expect probably gender and ethnicity, but they're encouraging more, but they expect at least 2. So that's the basic obligation. So what data do you have to produce if you're a large firm? At the moment, the proposal is to have a list of mandatory criteria and then some additional voluntary ones. So the mandatory ones there on the slide, which are, as you'll see, some of the core Equality Act discrimination protected characteristics. In addition to those, firms can go further with some of the characteristics on the right. Now, in the consultation paper, the FCA has said it may look to increase the number of mandatory characteristics over time as firms get more used to reporting this data. But as you can see, it's quite a significant number of characteristics for those firms who don't yet collect this data. And the other thing to mention on this is the obligation is to split it out by reference to board, senior leadership team, and other employees. So it's going to be quite granular and quite obvious, possibly, when you're looking at a population of a board. It's possibly going to show who's who, and you may be able to identify people, and that's been a concern that's been raised. So that's the diversity data. And then just to finish off, my last point on the regulatory update, non-financial misconduct. This applies to everyone, small and large firms. The FCA has said for some time since the Me Too resurgence a few years ago that they view non-financial misconduct, and what they mean is bullying and harassment. They view that as being relevant to the duty to act with integrity, which is already in the conduct rules. They've come out many times and said, we already view this as covered in our rules. They've decided now it's probably not that clear, and they're amending their rules to specifically include non-financial misconduct. And they're doing that in 2 ways, 2 main ways. They're including it in an amendment to the conduct rules, which, as you know, apply to all staff in a regulated firm, other than very administrative staff. And they're amending the fit and proper assessment criteria, which applies to senior managers and certification staff. Slightly different impact on those 2 groups, but essentially it's by and large the same instances of bullying, harassment, and similar behaviour. Interestingly, on the conduct rules, they've said they're only looking at serious instances of bullying, harassment, and similar behaviour. So I think there's going to be a lot of debate in individual cases of this misconduct of, yes, it is misconduct, yes, it is non-financial misconduct, but is it serious? And that's going to be a discussion, I think, that will be had. But this is significant, obviously, because it has an impact on firms' duties to report this, firms, if there is disciplinary action taken for a breach of the conduct rules, then that has to be reported to the FCA either straight away for senior managers and certification staff, or on the annual return for general employees. And so it's significant. Also, reg references, I think, will be impacted by this, because there'll be a duty to disclose this where there has been disciplinary action taken in regulatory references. So we'll wait and see what the final rules say. The devil will be in the detail, but at the moment, that's something definitely to look out for when those rules come out later this year. That is me, I think. And now I'll pass on to James to talk all things mobility.
Thanks, Chris. So today I'm going to go through some of the changes which have happened to the UK immigration rules recently, which mainly apply to employers, and also look at the proposals that each of the parties have come up with in relation to immigration. So let's move on to the next slide. So ultimately, we've seen a number of changes to the immigration rules this year, all aimed at reducing net migration. So net migration has doubled to the UK since pre-pandemic levels. So it started off at, so pre-pandemic, we were looking at about net migration of 300,000. So that's 300,000 more people coming to the UK than are leaving. And post-pandemic, we've now hit levels of 600,000. And most of the major parties think that is too many and want to introduce things to reduce that. So the current government has started doing that, has brought in a number of policies aimed at that. Significantly, it has raised all of the visa application fees, and it has increased the immigration health surcharge, which is the surcharge that migrants have to pay due to the fact they get access to the NHS, by 66%, so from £624 per year up to £1,035 per year, which is becoming a significant cost to both individuals and to businesses. But what I want to focus on a bit more now is the changes which have happened to the sponsor regime. So the category under which employers can sponsor migrants to work in the UK. So firstly, looking at the skilled worker. So skilled worker is a category which enables employers to sponsor essentially permanent hires in the UK. So the minimum salary threshold has moved from 26,200 up to 38,700. So a huge increase there. But not only has that gone up, but also the minimum going rate for salaries calculated has gone up, and they're now being referenced to the 50th percentile rather than the 25th percentile. Now, what this means is when you're looking to sponsor a skilled worker, you have to meet a certain salary threshold, and you either have to meet the minimum salary threshold for the category, so that is now 38,700, or you have to meet the minimum salary which applies to the particular job they're going to be doing as decided by the Home Office. So before, all of those salaries were calculated by reference to what is called the 25th percentile, which means means that migrants have to be paid more than the bottom quarter of all fee earners, bottom quarter of all wage earners in a certain job. They're now moving that up to the 50th percentile. That means that a migrant worker now has to be paid more than the bottom half of all wage earners within those categories. The government has also updated what's called the standard occupational classification code. So all of the jobs which meet the skilled worker criteria have a standard occupational classification code. So simply updated those from the SOC 2010 list up to the SOC 2020 list. This does produce some complications because some SOC codes have effectively disappeared, but there are transitional provisions in place to ensure that those who are currently doing jobs within those SOC codes which have disappeared are able to remain sponsored in the UK. The shortage occupation list is being replaced by the immigration salary list. Now, the significance of that is that the shortage occupation list was essentially a list of jobs where the Home Office recognised that they required skills which were in short supply in the local labour market, and what it meant that those on the shortage occupation list, those jobs were subject to lower salaries, so you didn't have to meet the 25th and now 50th percentile of minimum salary requirements, and also they were subject to lower application fees. This has now been replaced by the immigration salary list, which has the same benefits. So again, individuals who are doing jobs under the which are on the immigration salary list can be paid a lower salary and subject to lower fees, but there are less jobs on the immigration salary list than were on the previous shortage occupation list. And now supplementary employment is now permitted in any skilled worker eligible occupation. So beforehand, if skilled workers wanted to undertake supplementary employment, it had to be within the same SOC code as their current job. Now they can do any supplementary work in any job which is covered, which meets the skilled worker requirements. As I said, there are transitional provisions in place. Essentially, what that means is that those who are already sponsored, who are in the UK and already sponsored, they can continue, they are only required to continue to meet the same requirements that were in place when they were initially sponsored. And that's the case if they extend or that they move jobs as well. However, what the government is looking to do is they are going is that when they raise the salaries, because all the salaries are being adjusted for inflation, because ultimately they haven't really, the salaries haven't been adjusted for quite some time, so that the government is now adjusting those for inflation. So that means that the minimum salary threshold for those who are already here is going up to 29,000, as I said, and they're adjusting all of the rates for the going rate salaries. So for employers, it doesn't mean you have to do anything now. It just means you have to be aware of this when these individuals come up for extension to make sure that they meet the new 25th percentile threshold rather than the previous ones. These transitional arrangements will apply to anyone who had a certificate of sponsorship issued to them before the 4th of April 2024 initially, and are making applications anytime between the 4th of April 2024 until the 3rd of April 2030. Can we move on to the next slide, please? So the next category we'll look at is the senior specialist worker category. So this is the category for where employers are looking to move employees from their overseas operations to the UK on a temporary basis, so on a secondment or an assignment. So actually, very few changes to this category. The minimum salary threshold has been increased for the category from 45,800 to 48,500. Again, that is purely an inflationary increase because again, the minimum salary hasn't been updated for a number of years. And the minimum going rate salaries will continue to be calculated with reference to the 25th percentile. So if you're transferring individuals into the UK, they only need to be paid above the lowest quarter of wage earners within the job category. Again, those salary rates are going up in line with inflation, but it's still the 25th percentile. The high earner threshold, rather strangely, is staying where it is at 73,900. Now, the high earner threshold, essentially, that's used for is that if you're moving someone into the UK, if they're paid above the high earner threshold, they don't have to have worked for you for a minimum period overseas before being moved to the UK. But if they are below the high earner threshold, they have to have been working for you overseas for at least 12 months before they can be moved to the UK under the senior or specialist worker category. Again, there are transitional arrangements in place. These essentially mirror what's been done for skilled worker. It applies to anyone who has certificates of sponsorship assigned before the 4th of April 2024. And again, there are transitional arrangements to make sure to say that, that those individuals in that category, in that situation, can continue to be paid at the same levels, and to deal with situations where effectively SOC codes have been deleted due to the updating in the SOC code. Again, these will apply to all applications submitted after the 4th of April 2024 until the 3rd of April 2030. Next slide, please. So what does this mean for employers? So I suppose the good news, short term, there's no action for current sponsored workers. So there's no, I had a lot of queries from employers saying, oh, do we suddenly now, because the salaries have gone up, do we now need to increase the salaries for our employees? And no, you don't. There's no action to be done from that point of view. Medium to long term, when you're looking to extend sponsored worker or to sponsor a skilled worker who is already in the UK, say working for another employer, or that skilled worker has completed 5 years in the UK and is therefore looking to make an ILR application, it's important the employers take into account the inflation adjusted minimum salary. So you need to make sure the individual is being paid the amount, the new amount, which has been at least the new minimum, which has been adjusted for inflation. But obviously the big thing here is what happens when you're employing new skilled workers. So employers must now make sure that the salary on offer is going to meet the significantly higher minimum salary thresholds. And when doing that, employers must also make sure that this does not inadvertently lead to discrimination issues caused by a sponsored worker being paid more than a local worker. For senior specialist workers, simply employers must be aware and that that the minimum salary thresholds have increased making sure that when they are paying these individuals that they meet those minimum salary requirements. So moving on to the proposals of the various parties in relation to immigration. Unlike, say, for Labour, so Georgie, we can move on a couple of slides, please. So unlike what is on the employment side for Labour, actually they haven't released very detailed policies in relation, or proposed policies in relation to immigration. They are going to continue to seek to reduce net migration by reforming the points-based system, and literally that is all they've said. So we don't know what they were looking to do with in relation to the points-based system to do that, but they are continuing the Conservatives' policy of reducing net migration. They want to bar employers who breach employment or immigration law from sponsoring migrant workers. Now, I have to say, I don't normally sort of agree with things that the Reform Party say, but the Reform Party has pointed out that actually current law allows the government to bar employers who breach employment or immigration law. So that is not much of a change. They want to also create this integrated strategy to address skills shortages and improve where improved working conditions sits alongside filling vacancies through migration. So essentially what this all means is that Labour is looking to use the immigration system in a way which benefits local workers. They want to find ways to make sure that the immigration system is helping the local labour market. As I said, Labour says it's looking to reduce net migration. However, actually, really, if we are to have a Labour government, I think actually we won't see huge amounts of change, at least initially. The changes that the Conservatives have brought in the last 6 or 12 months are having the effect of reducing net migration. The numbers are coming down, and I think the Labour will adopt a bit of a watch and see approach to see whether or not that if net migration continues to drop, then actually they might not they might not bring in any major reforms at all. So moving on to the Conservatives, ultimately they are building on the changes that they've already done. So looking to raise the minimum income for family visas to 38,700. That is already their intention. That's already what they were looking to do. They also want to raise a skilled holder threshold and family income thresholds automatically in line with inflation. So those minimum salaries we've already talked about. They used to always go up with inflation, but they haven't done for a number of years. So they now want to regularly move those up in line with inflation. They want to require migrants to undergo a health check before they come to the UK. They want to increase the immigration health surcharge again, or require migrants to buy health insurance before they come to the UK. Look to increase all visa fees again, and remove the student discount to the immigration health surcharge, and introduce a binding legal cap on migration set on work and family visas. Interesting, the last time a cap was introduced on immigration, the government did everything they can to make sure that actually we didn't hit the cap, because they found out that when we did hit the cap, that meant that doctors could no longer come to the UK, because the way that the cap operated actually meant that doctors were being discriminated against. So it'll be interesting how they would see a cap working in the future to ensure that it doesn't particularly impact certain areas. Moving on to the Liberal Democrats, actually Liberals have got the most most detail when it comes to their immigration policy. I'm very aware of time, so I won't go through it in too much detail. But I think that the first line is the one that I'm particularly interested in. It's talking about replacing the current sponsored worker salary thresholds with a merit-based system. I do think I've always thought that having the basing an immigration system on salary threshold is a bit of a blunt tool. It basically favours people in highly paid professions and doesn't really take into account the needs of the labour market as a whole. So any change to that would be welcome. And the other one I will just draw your attention to is it talks about that the Liberals want to extend participation of immigration policy to devolved administrations. I don't think we'd ever move to an entirely regional-based immigration policy, but certainly I think that it's important that I've always thought that it's important that migration should benefit all geographic areas rather than just the southeast, which it tends to at the moment. Moving on finally to the Reform Party. Essentially they want to freeze non-essential immigration by bringing strict limits on immigration. They want to bar students dependents and only allow international students with essential skills to remain in the UK. The reason I mentioned the Reform Party was actually because I thought this was a rather an interesting idea they came with, not a good one, but an interesting one, which is to raise national insurance from 13.8% to 20% for overseas workers. The main reason I mentioned that is that I can see that being an idea that the Conservatives might look to adopt if they were ever to be if they did win the next election. So overall, what does it all mean? Labour is likely to, I think, under a Labour government, we are looking to have little or even no change. And the Conservatives, they're going to aggressively look to continue to reduce net migration by increasing the cost and potentially introducing a cap. The Liberal are looking at policy reform and moving away from using salaries as the sole way. Well, basically salary and cost is the sole way of bringing down migration, and reform basically no migration unless you're a doctor. So I think I will now that's all I have to say for this. So I will pass back to Miriam.
Thank you, James. So we've had a few questions come through, and just before we move to those, a reminder that we'll send the slides and the recording to those who were here today, so you can have them and you can review at your leisure. So the first question that we've had through is, I think for you, Chris, in relation to the new rules on non-financial misconduct, is the standard of acceptable behaviour the same as it is under employment law, or are there differences?
So I think there are. They've tried to make it broadly the same. I think there are differences. As I mentioned, there is a heavy emphasis on only serious incidents of non-financial misconduct will be deemed as coming within sort of the FCA's remit. So, and they said that they'll look at things like duration, seniority of the individual, and the impact on the recipient of the conduct. So I think that's different. Obviously, employment law doesn't necessarily make seriousness, the actual tiebreaker about whether or not something is misconduct or not. So I think that's different. They've also said there's a focus on intent rather than effect. As we know, in employment law, it's the effect someone's behaviour has on someone, whether they intend it or not. The FCA rules seem to be focusing more on intent, and if the behaviour wasn't intended, then there is going to be a more relaxed view of it, it seems. So, and I think also this distinction between what happens in what takes place in someone's private life, private and personal life, versus their working life is something that they are focusing on. They are going to be more interested in private lives of senior managers and certification staff for the fit and proper test, but under the conduct rules, they will not want to look at something that happens in relation to someone's private life. So I think that, again, and that line, I think, might be drawn a bit differently to the employment law line. So similar, but certainly some differences.
Thanks, Chris. I think whoever is elected, it's going to be continue to be an interesting time if you are a regulated employer with all of these developments. So looking at the next question, I think, Fran, this one's for you. When it comes to the extended protection we were talking about in terms of redeployment opportunities in a redundancy situation, what about those people on shared parental leave? How does the protection work there?
So that will depend ultimately on how much shared parental leave the individual has taken. If the individual's taken less than 6 weeks, then they won't have any protection under the new legislation. But if they've taken over 6 continuous weeks of shared parental leave, then that protection period will be 18 months from the date of birth of the child.
Thank you for that. Question for you, James, that's come through. Following all the reforms that have taken place in the UK immigration system already this year, are there any other changes on the horizon which we should be aware of as a business?
So the biggest question I'm getting at the moment is around the fact that all biometric residence permits are expiring at the end of the year. And this is the case no matter how long you've been granted immigration permission for. So essentially, the reason for this is that when we were, it's halcyon days when we were part of the EU, all immigration documents had an expiry date of the 31st of December 2024 because they were going to introduce more security features at that point. And the UK government has used that date as a date when actually we are going to go fully digital. So the UK is going to go fully digital with immigration, which means that the government is no longer going to issue hard copy immigration documents. Everyone will need to prove their immigration status online. So so that means that people have to access a portal in order to demonstrate their immigration status, and on that portal will be what is called an e-visa, so an electronic visa. And when individuals travel overseas after the 31st December 2024, they will only need to carry their passport with them. So they will literally, when they're coming back into the UK, give their passport into the airline. The airline will be able to check via their passport whether they have immigration permission to come into the UK have that immigration permission, and then they will be allowed entry. And if migrants want to prove their immigration status to anyone, they will do it again through this portal. So this is all due to be rolled out by the end of the year. Anyone with a BRP which expires on the 31st December is going to have to be required to register for what is called a UK visa and immigration account, where they will find their e-visa, and we're in the process of sending out communications about how individuals can do that between now and the end of the year. But the most important thing to know at this point is that even if individuals do register for their UK VI account and get their e-visa, they must still carry their biometric residence permits with them when they travel overseas up to the end of the year.
Okay, a few things for employers to think about then, even notwithstanding the election and what happens there. I think we've got time for one more question, and if we didn't get to your question, as I said, we will follow up in writing along with the slides and the recording. So last question for you, Chris. What do you think the impact of the changes will be on that the parties are proposing on employment litigation? I think let's focus on Labour there, just in case they win.
Yeah, yes, I'm not sure if the other party's proposal will have much impact, well, other than the reform ones. But I think if Labour, undoubtedly, I think employment litigation will increase, which is probably stating the obvious. But I think if you take the combination of unfair dismissal from day one, giving unfair dismissal rights to workers, and extending tribunal time limits to 6 months, the volume of claims going through the tribunal will surely increase. It's interesting. It's been said that there may be a decrease in unmeritorious whistleblowing and discrimination claims in the 2-year period after joining, because someone going forward won't need to bring an uncapped claim. They can just bring an unfair dismissal claim. I think that's possibly wishful thinking. I think there will still be discrimination and whistleblowing claims. There'll just be a larger number of unfair dismissal claims going through. And as I said, when you look at the delays in the tribunals, particularly the London tribunals, I think a Labour government is going to have to look at the resourcing of the tribunal system, because it is woefully under-resourced ever since the pandemic in particular, and it just needs more money. So again, it needs some funding, and the question is where that's going to come from. But maybe if it delivers some funding for the system, maybe that will cope. But otherwise, I think more delay in the tribunal system for us all, I suspect, is the likely outcome.
I agree. If they would just answer the phone, I think it would help some of us. Anyway, we're at time. Thank you very much to our panelists. Thank you to you for joining. We will follow up on the questions that we didn't get to in writing, as well as sharing the recording and the slides from today. Thank you very much.